All right, welcome back. So as we told you this morning, the DPP has issued instructions to discontinue the case against former Prime Minister Basdew Pandey, his wife Uma Pandey, Ishwal, and also Ishwar Galbaran Singh. All right. So on the line at this time, we do have Mr. Martin George. Mr. George, good morning.
Yes, hi, good morning to you and good morning to your viewers.
Mr. George, how do you see this? What happened yesterday?
Well, I mean, the thing is, we suspected something like this might have happened because the DPP did indicate at a previous time that he was looking at these matters, and particularly after the Privy Council had issued its dismissal of its decision in the appeal, whereby it said in relation to the Piarco 1 matter that, in terms of the committal to stand trial, that, it ruled that that was not something that could stand, then of course we always then began to wonder about the fate of the entirety of these matters.
Mr. George, make sense of this for us, for the layman. How does this happen after 18 years of spending money, resources, time? How does this happen?
Well, I don't think it's possible to make sense of it, Marla, quite frankly, because, I mean, the fact of the matter is that you're talking about millions and millions of taxpayers' money that would have been spent in this type of prosecution. And then, of course, there's now going to be the allegation as to whether this prosecution was conducted fairly or whether there was some element of malice in it. And that, of course, would be raised as a question purely because of the political dynamic and the political element to it. So, you ask yourself, in other words, is it that we in Trinidad and Tobago are unable to bring these matters to fruition and to trial and to conclusion? Look how quickly the matters in the US against Gutierrez and the others were tried. They were tried, convicted, sentenced, they served their time and were released. I think one died and I think the other was released, and they had enough of all of that occurring, and still we were not able to even really get anywhere or make any serious headway in terms of our prosecution of these matters. So it shakes the public's confidence in the entire judicial system.
And Mr. George, I think that is the concern, because persons are going to ask, in other jurisdictions, these matters are being properly ventilated and there is a conclusion. So is there something wrong in Trinidad and Tobago?
Well, I mean, the fact of the matter is that, I mean, of course, everyone is entitled to due process and persons are entitled to, I guess, file challenges to their prosecution if there's validity and merit to their claim. But the reality is that I think it's also a reflection on our justice system and our criminal justice system more particularly, because the matter has been through the court system for so long and for so many years that you have this scenario where basically, I mean, it really borders on what some might consider to be an abuse of the process, in that, look, why is it so long? I mean, of course, most of the delays have been in some way due to applications that were filed. But the point is there were several delays due to the state itself not really having its house in order at times when they ought to be able to proceed with this prosecution. So once again, the ordinary citizen in Trinidad and Tobago is the one who actually bears the brunt and burden of this, because all you have is lots of, money being spent all around in the millions on legal fees and absolutely no, successful conclusion as regards the prosecution's perspective.
And I'm sure, Mr. George, you would agree that if the state is not available or is not ready, and it's how do I say, it's an argument that is being used over and over. There are delays. Sometimes the state is not ready. Sometimes the prosecution is not ready. So how do we correct this?
Well, I mean, the fact of the matter is, I mean, the DPP did indicate recently, and he alluded to his tremendous staffing shortages and the fact that, they are under-resourced in terms of the numbers of attorneys whom they need to prosecute matters. Then, of course, you have some of the senior attorneys who've been appointed either as judges or masters or registrars of the High Court. So therefore, they suffer a loss there. They have some members of their staff who are appointed to the magistracy. So again, you have a loss there. Then you have persons who get opportunities overseas and they, opt for that. So it comes back to a question of, I guess, first of all, the staffing and the resourcing. But separate and apart from that, I think we in Trinidad and Tobago, we need as a people to start calling upon our successive governments to revisit the entire idea of these legal briefs to external attorneys and how they are, first of all, I guess, treated with, distributed, the level of accountability that one calls for from these attorneys who are briefed externally, and of course the question of, I guess, maybe the pricing of them, because I think the public is beginning to get wary and wary. So in both spellings of the word, of this entire scenario, so therefore they are kind of questioning, why do we continue this cycle which ends up in this type of imbroglio and, with the state with basically egg on its face at the end of it all.
Yesterday, the DPP said that that key witnesses were unavailable as some had died, and one was an elderly person who lived abroad. And Gaspard explained that it had to be considered whether there was fair prospect of conviction in the matter. As it relates to witnesses were unavailable and some had died, the question is, couldn't persons be interviewed before they died?
Well, the point is, I mean, we in Trinidad and Tobago, we have, as part of our law, the possibility of paper committals. In other words, you take statements on paper, you have them sworn, and those statements are tendered. However, you have two aspects that you have to consider. At the time when this matter was instituted, you have to ask yourself, was it a paper committal, first of all? And then secondly, you have to ask yourself, even if there's a paper committal, the question will eventually arise as to the need for these witnesses to be cross-examined on their statements. So the paper committal only seeks to expedite the first part of the process, which is the preliminary inquiry in the magistrate's court. And that's where these matters still are, unbelievably. They still are at the magisterial level. The one that had been committed, where persons had been committed to stand trial at the High Court, that's the one where the Privy Council recently quashed that committal and indicated that, it appeared not to be something that could stand.
All right. So we are going to give you the opportunity, members of the public, to call in if you would like to comment on this matter. Now, the thing is that be respectful, and let's be very careful as to what we are saying. We don't want to slander persons and so on, all right? So you will get the opportunity. You can call us on 623-1711, and the extension is 1995. One other point, Mr. George, is that at least two persons, Carlos John and Ishwar Galbaran Singh, they are today calling for a commission of inquiry on one count and an independent inquiry into this matter.
Well, I mean, I would want to see what exactly they are seeking to have a commission of inquiry into, because let's not forget that there actually had already been a commission of inquiry into the Piarco scandal. Again, that was an exercise that cost taxpayers millions of dollars and yielded no real tangible result. So, you ask yourself again the question, what is this going to achieve if we do have a commission of inquiry again into these issues? So, I think that the public, as I said, is not really at the point where they are willing to accept just, whatever is said in terms of these matters, in terms of you appointing a commission of inquiry, because I think people are generally beginning to feel that, look, it's just an exercise in sophistry, and that you are just basically, engaging in a grand charade to make it appear that you're trying to do something, when it seems that the result in most of these matters ends up being a foregone conclusion.
All right, Pointe-a-Pierre is on the line. Good morning, Pointe-a-Pierre.
Yes, pleasant good morning to you, Marlon. Pleasant good morning to you, George. Mr.
Yes,
George,
sir.
could you kindly tell me how many times this matter in the 18 years would have come to the magistrate's court and stood down? Is it 3 times a year, 4 times a year? How often would it be stood down? And for what reason? And would not the magistrate ask questions as to why this is being stood down so many times? Thank you.
Thank you.
All right. Okay. So I don't know the numbers. I was not involved in the prosecution or in the defense of the matter. So those would be matters for the court records. But it's clear that the matter would have been called, maybe more than 100 times in the 18 years, if you understand me. It's a high-profile matter. It's something that people would have wanted to get on with. And, there have been many twists and turns and many back and forths in the matter. So the caller's question is actually very valid in terms of, again, a reflection on our criminal justice system in terms of the number of adjournments, particularly in criminal matters, that are afforded.
All right, thank you very much. Pleasantville is on the line. Good morning, Pleasantville.
Morning, gentlemen.
Yes.
Mr. George, one of the reasons for the situation of the matter was inexcusable delays in our court. We are hearing over and over about our courts. Now, the judiciary is one of our independent arms of government. The legislature accounts to the people in Parliament. The executive does. How are we going to get the judiciary to account? Should we have some sort of inquiry into what's happening in our judiciary? We need the answers, and this is what we are not hearing.
All right, thank you very much. An inquiry into the judiciary.
All right, okay. So, the thing is, the question is that you recognize that, yes, the judiciary is independent. It does not mean that they are above scrutiny or that they are, without any means of, inquiring into them. In fact, if we recall the 1936 Privy Council case, Marlon, Ambad versus Attorney General, that's actually a case that was from Trinidad and Tobago, right? And since 1936, the Privy Council, through Lord Atkins, said justice must not be a cloistered virtue. She must be allowed to suffer the searching yet respectful scrutiny and comments of ordinary men. And just exactly as the callers are doing, and they are raising questions, they are fully entitled to do so. And of course, every year the Chief Justice puts out his report, at the start of the law term, in accounting for his stewardship, so to speak, and the stewardship of the judiciary in terms of, dispensing justice for the public. But clearly, I think we need to, have further discussions such as what we're having now, Marlon, because issues are on the table which are unresolved.
Tabakit is on the line. Good morning, Tabakit.
A pleasant morning to you, Marlon.
Morning.
And to your person and to your guests in studio.
Yes.
Look, concerns, 2 things jump up in front of me. First of all, he didn't say innocent or guilty, and the second is a lack of evidence. But I'll tell you what is
Tabakit, if you could change your position a little bit so that we can hear you clearly. I don't want to do you a disservice or members of the public a disservice. Go ahead, Tabakit.
You hearing me better now?
Stay right there. Yes, go ahead.
Right. 2 things that what you have is a lack of evidence, and number 2, they didn't say or guilty. But what is this? The citizen need to fit bill for what in the whole can't do.
Tabakit, we're having great difficulty.
It broke up a lot, but I mean, what I gleaned from his question,
yes.
It appeared that he raised the question that there was no pronouncement of innocent or guilty, and the third point he made seemed to be that citizens had to foot the bill.
Yes.
And the second seemed to be that he talked about a lack of confidence, I guess, in the judicial process. And, you know, in terms of the first one, well, in this scenario, when you are discharged, there's no pronouncement to say innocent or guilty. But the fact of the matter is, if the matter against you is discharged, then, of course, the presumption of innocence that you started with remains intact. So there's no pronouncement of innocence, but, of course, based upon the presumption of innocence, you are basically able to proclaim to the world that, look, my innocence remains intact. All right, so that answered the first question. In terms of the second issue that was raised, the lack of confidence, well, I think it's pellucid that there is that lack of confidence by the general public, because we have seen this scenario played out over and over again in Trinidad and Tobago, and citizens, I think, are becoming justifiably frustrated, Marlon.
Yes.
Justified.
Kuva's on the line. Kuva, good morning. Kuva, you're there?
Yes. Good morning.
Good morning.
Listen, could we look at this in a different perspective, but in a manner that the citizens are viewing this? Now listen, we have grown accustomed to the people who are extremely rich in our society not being able or have not been convicted in this country of a history of that. There must be a reason, putting aside all the fancy intellectual and judicial talk, right? That is how the society is. It's a kind of a spin-off from colonialism, right? The rich or the planters and the planters' friends and families are not to be persecuted by the constabulary, because that is the fact.
Thank you very much.
Yeah, and again, that comes back to the question of the confidence that the public will have in the judicial system, because it will appear, and I mean, the caller has put it quite succinctly, you know, that basically there's one law for the rich and one law for everyone else. And, you know, that again does not inspire confidence in your judicial system when persons are seen on a regular and repeated basis that persons with deep pockets and persons who are well-heeled, you know, are able to, I guess, frustrate, thwart, thumb their noses basically at the judicial system. And you have a scenario where, you know, some small person, you know, is arrested, is, you know, hauled before the courts, and, you know, within a matter of weeks, they're sentenced and, you know, convicted and, you know, thrown into prison. So it really does, you know, irk the national conscience, and it does make persons feel that level of dissatisfaction with the way the judicial system functions. And I fully empathize with that caller from Cuba.
Aruka is on the line. Good morning, Aruka.
Good morning. Good morning.
Morning.
Today is a real sad day in Trinidad. Our justice system only works for the poor, and who have more corn feed more chicken. And people must not forget the role that Ramesh Chevasudama and Ralph Barach played when they was exposing the corruption within the UN when Basde Pandey was the Prime Minister.
All right.
Well,
all right. Thank you very much.
Right. I mean, as regards the first aspect of his point, and you know that's exactly a follow-on from what we've been saying all along. But you know, he started by saying it's a sad day. But I mean, the point is, I would think that certainly for the persons who were before the court, the defendants and their families and friends and well-wishers and supporters, it's actually maybe a day for rejoicing for them. You know, because, I mean, at the end of the day, being through the court system for 18 long years could not be an easy thing for anybody, regardless of which side of the fence you're on. So, I mean, while I understand the caller's perspective, you know, not everybody is sad about this decision. Let's remember that.
But you know, Mr. George, even as it relates to calls for a commission of inquiry or an investigation into this matter, and there's a perception in Trinidad and Tobago that these independent inquiries are now being seen as an exercise in futility because, yes, you have all of this information coming out at the inquiries, but what happens at the end of the day?
And that's what I'm saying, Marlon. So, you know, I don't necessarily support a call for a new commission of inquiry yet again, you know, because it sometimes ends up just being a grand charade and, you know, what we would say in the local parlance is a pappy show. You know, so you give the impression of trying to do something, but there are so many commissions of inquiry we have had, first of all, where the government of the day refused to either lay the report in Parliament or refused to make it public, you know, refused to divulge the details. There's been little or no follow-on or follow-up. Remember, we've had our fill of commissions of inquiry. I mean, going far back as, you know, you had the Wooden Commission, you know, from early o'clock. You know, you had the Mustill Commission. You had so many of these things. You know, and really and truly, Trinidad and Tobago, if we look at ourselves and you ask yourself, are we better off for having had those? And it doesn't appear so.
Yeah, so what do we do? Do we continue along this path or do we call on people to become more accountable? What do we do? There has to be a review of something.
Well, the most fundamental change that can be effected, Marlon, would be the question of constitutional reform. You know, doing an overall, an overhaul of our entire constitution and, I guess, the fundamental pillars which constitute the building blocks of our society. But that has always been a political football between our two major parties. You know, in that, you know, when one parties on one side, they call for it, but then when the roles are reversed and, you know, they're in opposition or so, then, you know, they change their story. So, you know, it's really something that I think we as the citizens need to start making that type of call and start, you know, making that kind of, you know, clamor so that we are heard on these issues for some real and meaningful change. Otherwise, we basically are ending up in a scenario, Marlon, where we are just repeating the same cycle over and over and hoping for different results.
We're spinning top in mud, Mr. George. Mr. George?
Well, that's so eloquently put.
Not as eloquent as you, eh? But thank you very much for your insight this morning. Always thank you very much for your contribution. We will speak again. Thank you very much, sir.
You're welcome. Thank you.
All right, so we are going to a very short break. First, we have this update for you at the Eddie Hart grounds, but we are going to be continuing with your calls after the break. Remember, you're calling us on 623-1711. The extension is 1995. We're coming back.
Must be in a quandary. This question is the hardest of us. But when to God these gods.